Hello, and welcome to this Pin St Masons and ICC joint webinar series on the ICC Commission report. Please note this session is being recorded. All delegates are in a listen-only mode, and if you'd like to ask a question, please use the Q&A function shown at the bottom right of your screen. We will try our best to answer these at the end of the session. We will also be asking polling questions in this session, and the option to answer will appear on the right-hand side of your screen when the time is right. I will now hand you over to your first speaker. Nicholas, please unmute and go ahead.
Slide 2, please. Please allow me to extend you all a warm midweek welcome to this, our 5th seminar in the 6th seminar series discussing the important ICC Commission report entitled Construction Industry Arbitration, Recommended Tools and Techniques for Effective Management, the 2019 update. I'm Nicholas Brown, and I have the honour once again of chairing today's seminar. It's brought to you today through the combined talents and efforts of the following practitioners. Firstly, acclaimed international arbitrator, international judge of the Singapore International Commercial Court, and a contributor to the 2019 update of the report, Mr. Justice Douglas Samuel Jones, AO. Counsel of the Secretariat of the International Court of Arbitration, based in Singapore, Ms. Hazel Tang. The very experienced international construction disputes lawyer, Mr. Frederick Gillion, and 5 renowned construction project experts listed in alphabetical order, Mr. Jerry Brannigan, a partner of HKA, Mr. Don Harvey, the founder and managing director of Secretariat, Ms. Joanne Pryor, managing director and quantum expert at Kroll, Mr. Michael Stokes, senior managing director of Incura, and Mr. James Taylor, senior managing director at FTI. We all wish to thank you for attending today, and we trust you will find what we share with you today will be of great interest and assistance. Slide 3, please. We will begin in about 5 minutes past the hour with Hazel offering us an insight into the ICC's perspective on the key considerations, tools, and practice techniques for the reception of witness evidence in construction industry arbitrations, utilising the tools and the techniques outlined in the ICC Commission's report and more recent guidance. Then at about 25 minutes past the hour, Professor Doug Jones will share the vital perspective of a busy commercial arbitrator and, since 2019, an international commercial judge on the effective reception of witness evidence by the arbitral tribunal in a construction industry arbitration, again, in light of the beneficial guidance of the report. The report states in its preliminary remarks that it's intended primarily for an arbitrator who doesn't have much experience in construction arbitrations conducted under the ICC rules, or who wishes to be reminded of the options available or of good practice techniques exercised by others. And I can think of few international commercial arbitrators out there who are better placed than Doug to amplify the report's recommendations and to explain how he implements them in his arbitration cases. At around 1:15, my law partner, Frederick Gillion, will address you on counsel's strategic perspective as to the tools and techniques set forth in the report. This should prove particularly interesting to business users of the ICC's arbitral services for construction industry arbitrations. It will highlight some of the challenges faced by parties' representatives in getting the most from progressive case management techniques. Ordinarily, the seminar would then move on to a role-play phase, including our 2 fictionalized practitioners, played by my colleagues, Ms. Andrea Clark and Mr. Yongning Chan. Well, this time, however, we're conducting a panel session. You might regard it as a hot tub of sorts. In this 40-minute session, ably facilitated by Doug, you will hear concurrent expert views on several of the respondents' recommendations on the effective provision and reception of expert evidence, including in light of the new normal. At 1:45, I will offer closing remarks for not more than 5 minutes, summing up the preceding presentations before we turn to the question and answer session. And if we've kept to schedule, there will be a good 10 minutes for that. Throughout the seminar, we'll be raising poll questions for your consideration as you watch and listen along. So please look out for the announcements and let us know your views by selecting the most appropriate answer. We hope you'll find them engaging, and we will then come to the panel session and address some of the answers that have been posted. I will then close the seminar on the new hour, returning you neatly back to your day's business or pleasure, and I trust you will enjoy the seminar today. Slide 4, please. Now it gives me pleasure to invite Ms. Hazel Tang, Counsel of the International Court of Arbitration of the ICC, beaming in from Singapore to address us on the ICC's perspective of managing witness and expert evidence. Hazel is the counsel in charge of the ICC Court of Arbitration case management team. Before that, Hazel was the Centre Director of the Singapore International Mediation Centre, an arbitrator and an accredited mediator in Singapore and Shanghai. Hazel was also a partner with a leading Singapore law firm with a regional presence and was based in China for a period of time. Hazel's experience covers a wide range of contentious and non-contentious work in the construction and infrastructure industry, and she has effectively represented clients in international arbitration, litigation, adjudication, and mediation proceedings. With that introduction, I'm very pleased to pass it over to you, Hazel.
Next slide, please. Time and cost has always been the main considerations of parties during arbitration, in addition to winning the case, of course. And as part of ICC's continuous efforts to improve the use of international arbitration and other forms of dispute resolution practices, this commission report was commissioned in order to contain recommended techniques to ensure that proceedings are conducted in an effective and cost-efficient manner. Before I begin discussing the report, however, I would like to highlight that there is no single right way in which a construction arbitration should be conducted. Every case is different, and it is up to the arbitral tribunal, in consultation with parties, to decide what is best for that particular arbitration. This report sets out certain recommended techniques and skills that can be used, and the factors that the arbitrators and parties may bear in mind when considering whether the techniques are suitable for the case at hand. Next slide, please. The first edition of this report was actually commissioned in 2001, and this was to provide guidance on a range of tools and techniques for use in successfully managing construction arbitrations in particular at that time. As Nick has highlighted, the report was intended primarily for arbitrators who do not have much experience in construction arbitration under the ICC rules and who wishes to be reminded of the options available or of the practice of other more experienced arbitrators. Now, why construction arbitration specifically? Well, construction arbitrations are no different from other international commercial arbitrations, except perhaps that they're frequently more complex, both factually and technically, and they can generate difficult points of law and procedure relating to specialized forms of contract unknown to those who are not involved in construction. Most of the time, construction arbitrations also seem to require many more documents to be examined. This report was positively received by the construction arbitration community when it was first commissioned in 2001, and the tools and techniques recommended have been adopted in many institutional and ad hoc arbitrations, not just in construction disputes, but also in other types of complex arbitrations. Hence, in 2016, the ICC Commission's steering committee decided it was time to update the report to be in line with the present practices and also in view of the new 2017 rules at the time. In 2019, an updated report was provided with two main objectives. One is to reflect the various modifications to the ICC rules in 2017, and it remains to be seen whether another report may be required in light of the current situation and the new 2021 ICC rules, that came into effect this year. The second objective of the update to the report is to reflect recent developments in the practice of arbitration in construction disputes. Next slide, please. The report covers the entire arbitration process as reflected in the 6-part series, all the way from the composition of the tribunal to the hearing itself. Today, we're going to focus mainly on witnesses, factual, and experts. Next slide, please. Before we start looking at the recommendations, however, it may be useful to start by looking at what is provided under the ICC rules in the first place when it comes to establishing the facts of the case. Now, under the ICC rules, Article 25, it is provided that the arbitral tribunal shall establish the facts of the case by all appropriate means. The arbitral tribunal may also decide to hear the witnesses in the presence of the parties or in their absence. In addition, the arbitral tribunal may also, after consulting the parties, appoint one or more experts on their own initiative, define the expert terms of reference, and receive the expert's report. At the request of a party, the parties shall be given an opportunity to question the expert at any hearing. The arbitral tribunal also may, at any time during the proceedings, summon any party to provide additional evidence. Of course, and especially prevalent in these days, the arbitral tribunal may also decide the case solely on the documents submitted by the parties, unless any of the parties request a hearing. Next slide, please. I will approach the recommendation in a timeline manner and first look at what are the recommended techniques that parties and tribunals can consider before the hearing itself. Now, it is not uncommon to see an agreed set of facts or facts which are not in dispute, and it's certainly useful before the hearing for the tribunal to get parties to agree on a set of undisputed or agreed facts, or at least allowing such facts to be stated on the record without the necessity of witness testimony. This way, parties don't need to spend time procuring witness evidence on facts which are not in dispute, and this effectively does save a lot of time and cost. Even where full consensus cannot be reached, it is often useful to reach consensus on as much of the chronology of facts as possible, and leaving those in dispute to be discussed by parties. It is also useful to reach a consensus with parties on the role and content of the witness statements that they intend to produce for the hearing, so parties know what evidence they need to address in the course of their own submission. Of course, the witness statements should maintain only what is relevant and keep irrelevant information out of the scope. It is often important and useful for the tribunal to minimize the timing between exchanges of witness statements and to minimize the rounds of exchanges. Usually we'll see one round of witness statements followed by one round of reply statements, and that should be it. It is also useful for the tribunal to set deadlines in good time before the preparation of pre-hearing submissions. This is because in order to effectively prepare the pre-hearing submissions, parties and the counsel need to know what is the evidence they have to address during the hearing. Often, in cross-border disputes, where evidence are not provided in the language of the arbitration, it is important for parties to agree on whether translation is necessary. When it comes to the use of translators, it is also important that where the statement deals with technical or legal matters, the tribunal and parties in consultation should ensure that the translator is both qualified and familiar with the subject matter. Otherwise, the translation may not only be useless, but even worse, misleading to the tribunal. Next slide, please. During the hearing, Yes, this is the slide. Please stay here. During the hearing, the tribunal should mandate that witnesses should only be called and heard if required by the party or the tribunal themselves. Where a party makes a reasoned request to call and cross-examine a witness, the tribunal may ask the party to state why a witness is required and to specify the areas in which the questioning is to be conducted so as to ensure the relevance and necessity of the witness testimony. It is advisable that the tribunal provide, probably in the first procedural order, for the parties to notify each other well in advance of the hearing if a witness is not required for questioning, and if so, what is the status of evidence of that witness. The tribunal should also warn the parties that in its decision on cause under Article 38 of the ICC rules, it can take into account costs wasted by witnesses having to attend the hearing unnecessarily. The procedural order should also deal with the status of the evidence of any witness who does not appear without reasonable cause. In addition, parties, especially in this time, should discuss whether video link is possible without personal or physical attendance of the witness at the hearing. During the hearing, it is also not uncommon for parties and tribunal to discuss and agree on reasonable time limits for questioning of the witnesses. The techniques, the approach, and the limits of the questions, particularly by cross-examination, should be agreed with the parties beforehand to align potentially divergent expectations in advance of the hearing. For example, whether questioning should be limited to matters within the witness's personal knowledge. This ensures that hearing time is used effectively, and some tribunals may even require each party to notify each other beforehand of the scope of the proposed question. However, such a clause can lead to the witness becoming aware and preempting intended questioning, and in any event, adequate notice will have to be given for this, and at least 48 hours, if not before the hearing. And this may not be particularly suitable in certain arbitration. Another tool that can be considered for the purpose of using hearing time effectively is, in fact, fact witness panel. Guidance in this is actually provided for under Article 8.3F of the IBA rules. Fact witness panels can streamline the process in complex cases where there tend to be many factual witnesses who have complementary or supplementary information on the same subject or on the same time period. Fact witness panels can then be questioned on the same topic at the same time without losing momentum, and this can consist of fact witnesses from one party or from both parties, and it's similar to what we now know as the hot tubbing process for expert witness conferencing. The use of fact witness panels may provide particular focus on the examination of key facts and documents, thus reducing repetitive evidence, and can serve to bring out the real facts better than by a single witness, one at a time approach, which is the traditional way of cross-examination. It may also permit concentrated attention on the issue by individual theme or topic, and this is particularly useful in construction arbitration, where there is likely to be overlap in the evidence of witnesses in timeline or on topic. Next slide, please. On expert witnesses, first, I think it is important to avoid any confusion. It is suggested that the tribunal consult the parties at the first case management conference to find out whether they both intend on tendering evidence from experts, whether technical experts or legal experts, and why such expertise is required. Also, quite often in construction cases, one finds witnesses who combine both features of a factual witness and those of an expert witness. For instance, it may be that experts are being used as consultants in the project from a very early stage in order to assist with the preparation of claims. In these instances, perhaps such evidence can be provided in another way, not in the form of expert evidence. They should be distinguished from experts unconnected with the parties, such as specialists renowned for the expertise in a specific area, although the dividing line is not always clear. The tribunal will need to bear in mind this distinction when assessing the weight of the opinions presented. If the parties wish to present evidence from experts, the matter should be discussed with the other side and with the arbitral tribunal as soon as possible. And the tribunal may check the scope of the evidence in order to ensure that the expert evidence is confined to the issue and does not deal with matters which are capable of being proved in other ways. Sometimes parties may require assistance to meet this objective and prepare the terms of reference for the expert. In this case, one solution would be for the tribunal to get involved to help parties draw up the terms of reference for the experts on the basis of the issues known to it, or to request the parties to agree on a statement of the issues and facts, both agreed and assumed, for instance, to be set out in the witness statements, and perhaps even to the extent of what documents will be provided for the expert to give his evidence on. The experts should be transparent about the terms of reference or instructions they have received from the client subject to legal privilege, so as to enable the tribunal to ascertain that clear directions and explanations have been given in order to obtain a useful opinion from the expert. It is also desirable for independent experts, whether acting as expert witnesses or technical consultants, to discuss their views with each other before preparing their reports, if they are truly independent. After the experts issue their report, they often become too committed to their position and are less likely to be open to changing their written views. Even if no discussion is possible before the report is submitted, a discussion between the experts should certainly be held after the report has been submitted. For such expert meetings, there is normally no reason why anybody else needs to be attending. There may, in some instances, where the tribunal's attendance may be required, but this is not strictly necessary. There may also be cases where the parties will be saved considerable time and expense if the tribunal appoints its own expert, as the expert's opinion may render unnecessary any further expertise or identify points upon which evidence or reports from witnesses or experts may be required. And I think this will be elaborated further by my fellow panelists in their discussions later. Situations in which the tribunal may decide its own expert can include if the parties have not provided adequate technical information, or where upon assessment of part of the case will take considerable time. Where the opinions of experts are important and any differences are not attributable to different perception of facts, the tribunal may also decide to appoint their own experts. In this instance, the ICC actually provides services to help the tribunal choose an expert, and no administrative charges are levied for this. It is, however, important to bear in mind that even if the tribunal appoints its own expert, they have to make up their own mind on the issues that are presented before it. The experts' opinions are not binding on the tribunal clearly. At the end of the day, one of the most important techniques often used in construction arbitration is for experts to produce a joint report with reasons for the differing opinions. This will be of great assistance to the tribunal so they can focus on the distinctions and the reasons for the differences, and this will save considerable time when considering expert evidence. We will expand more on the recommendations in this report in the course of the seminar. And with this, I end my presentation and I look forward to receiving your questions at the end of the seminar. Thank you.
We're going to ask a question of the audience now, and you should see a polling question appear on the right-hand side of your screen in just a moment for that. Great. What has been your experience with fact witness panels? So to recap, this is where we have multiple witnesses who have complementary information on the same subject and can be questioned together. That's similar to what's done with expert witness conferencing. I'll give everyone just a few moments to log your answer. Okay, let's go ahead and close the poll. We'll tally the results and hold them over for the Q&A session later on. And with that, I'll hand over to Nick. Nick, I think you're on mute.
Thank you. Thanks, Andrew. And thank you, Hazel. I'm sure that our guests have appreciated your insights into the ICC court's case management practices reflected in the rules and in the ICC Commission's report. And thank you very much for outlining those prescriptions. May I have slide 13, please? It gives me great pleasure now to invite His Honour Justice Douglas Samuel Jones, AO, beaming in from Canada to address us on the arbitrator's perspective of managing witness and expert evidence in construction industry arbitrations in light of the revised report of the ICC. Before His Honour begins, I'll offer this doubtless all too brief introduction since his 4-decade legal career is packed with pioneering achievements and services to the construction industry internationally. Perhaps the highlights of his career would include his various leadership positions within the Australian law firm Clayton Utz from the early 1990s through to his retirement from the firm in 2014, his receipt of numerous honours, including his appointment as a member of the Order of Australia for services to the law, particularly in the field of construction law, and to the development of arbitration and ADR methods. For present purposes, perhaps what's most noteworthy are his professional posts, his professorial posts at Melbourne University and King's College London, his presidency of the Chartered Institute of Arbitrators in 2011, his presidency of the International Academy of Construction Lawyers from 2018 to 2020, his services to the international business community as an arbitrator in both ad hoc and institutional commercial arbitrations under almost every major set of institutional rules. And by no means least, in 2020, his receipt of the Global Arbitration Review Award for the best prepared and most responsive arbitrator, which in my own experience is another award that he richly deserves. With that all too brief introduction, I'd like to now pass over to you, Doug.
Thank you very much, Nick, for that very generous introduction. And it's a great pleasure to be participating in this event, which highlights a very important job of work done by the ICC Commission, contributing to increasing the efficiency of construction arbitration, which of course represents of the order of 50% of international arbitrations around the world. The devil, though, is in the detail of the recommendations, which are necessarily presented in a summary form in the Commission's report, highlighting areas where innovation can be undertaken and ideas ventilated between tribunals and parties to make the process more efficient. I propose to concentrate in the time I have available on the expert evidence aspect of the report. However, it is important to understand that along with the cost and time involved in deploying expert evidence in construction arbitrations, the cost and time of preparation of factual witness evidence is also of great significance. And one of the challenges that we face as participants in the process is trying to ensure that there is a more focused effort on the presentation of the written witness evidence, which is presented on behalf of factual witnesses. And in this respect, I just note briefly in passing the reform efforts undertaken at the moment, most recently, in the London Commercial Court, where the issue of witness statements has been the subject of some very detailed reform rules, and which may provide some basis for exploration in international arbitration. Can I have the next slide, please? However, what I would like to concentrate on in the context of expert witness evidence is the issue of party-appointed experts in international construction arbitration. Of course, there are two methods of appointment of experts. The tribunal can appoint its own expert or experts, which is, of course, a very civil law tradition in domestic civil law proceedings, or the parties can deploy their own experts before the tribunal. My experience is, though, that the majority of experts deployed in international construction arbitration are party-appointed experts, and I'll concentrate on them. Just very briefly, though, it is important to remember that there are, in my view, three types of expert. We will have a hot tub shortly with the first category of expert, which one sees in international construction arbitration. And they are the experts who assist the tribunal in the areas of delay, disruption, and quantum. There, the role of those experts is very important for tribunals because, as all of you in the industry would be well aware, construction projects produce massive amounts of data. It used to be in writing. It's now mostly electronic. But over the period of a project, it is massive. And there is no way that tribunals can come to grips with all of the data that's contained within a project record relating to particular disputes. So these experts on quantum delay and disruption help the tribunal by analysing the data and then deploying their expertise in the analysis of that data so that outcomes relevant to the contentions between the parties can be dealt with. Those experts appear regularly. They're well familiar with the process of giving expert evidence to tribunals, and you will hear some very interesting views from them during our hot tub. The second category of expert is the person who has a particular subject matter expertise, be it a metallurgist or a weather expert, who often, in my experience, may not be a regular contributor as an expert witness to the process of international arbitration, but comes to provide a particular, usually narrow, area of expert opinion. And the third category of expert are the legal experts, because in many cases, there are differences of view between the parties relating to legal principles which go beyond the law that governs the particular contract between the parties. It might be legal principles governing the control of construction at the site, which may be a quite different jurisdiction to the contract law that one needs to consider. And these legal experts, in my view, fall into a quite separate category because deploying lawyers as experts has its own challenges. But just bearing in mind those three categories of expertise which one finds amongst party-appointed experts, let me frame the issue of the efficient deployment of party-appointed experts. In the common law world, domestic jurisdictions have struggled for many years with the difficulties posed by parties bringing to the courts their own experts on particular issues. And I mentioned, just by way of example, medical evidence in personal injury cases, where many medical practitioners in common law jurisdictions have long given up actually helping the sick and have full-time careers in appearing in court, either for plaintiffs or defendants. A whole area of medical expert evidence, which, according to the analyses associated with law reform, have more or less miserably failed to actually bring to the courts real expertise, but rather have provided advocacy on behalf of either a plaintiff or a defendant of a particular view about the effect of the injury, the subject of the medical negligence case or the personal injury case. So we have struggled in the common law world with trying to actually get value out of party-appointed experts for many years. That has not been the position in the civil law world, where tribunals traditionally, in a domestic context, appointed their own experts. However, as I mentioned a moment ago, we see now in most international construction arbitrations, party-appointed experts rather than tribunal-appointed experts. And the civil lawyers who are well represented amongst counsel in international construction cases have not had the long history of difficulty with party-appointed experts, and they embrace with enthusiasm the concept as part of their advocacy role. So the outcome of this is the challenge of tribunals and parties to get real value from these experts, to ensure that they aren't just part of the counsel team advocating within their area of expertise the views which support the contentions that each party has, but rather provide actual expertise, firstly to enable the parties to know what the real issues actually are, as opposed to the ones that are potentially runnable but unlikely to succeed, and for tribunals to get benefit from the experts within each area of discipline. Sadly, where the experts remain as part of the advocacy team, so to speak, they often present views which pass like ships in the night, and the tribunal is left with a choice between one expert's view or the other, rather than the opportunity to get true value from the expertise of these party-appointed experts. So I'd just like to briefly identify, and we will discuss shortly, some of the issues which are live, and for those of us concerned with the efficiency of international arbitration, are being deployed in an attempt to achieve a more satisfactory outcome for the party-appointed expert evidence than has hitherto been the case. Firstly, the identification early on of what actual areas of expertise are needed by the tribunal to decide the issues in contention, limiting where necessary flights of fancy, which just waste everyone's time, because there is actually no need for the expertise. Then, once the areas of expertise are established, identification of who the experts are within each area of expertise, so that at least in a preliminary way, early on, there can be objections raised to the particular experts sought to be deployed by the parties, either by way of conflict problems or by way of objection to real levels of expertise. The next issue is to try, obviously enough you might say, to get the two experts within each area of expertise to actually answer the same questions. Questions which, of course, reflect the case theories of both parties, but which ensure that you get both experts expressing a view on the same questions. You might say that's blindingly obvious, but it certainly is not often the case, because parties concentrating on what they wish to contend for will just think of their own advancement of position without recognizing that the other expert should usefully comment on that party's position as well. The fourth issue is to get experts to have common data set, documents, witness statements, and the like that each of them have seen, and to have available to both experts the material they genuinely believe they need proportionately to express a view. Getting a common data set also makes obvious sense, but is not always readily achievable. The next question is, what do the experts do when they answer the questions? Do they get together, exchange views on a without prejudice basis, that is, a basis that can't be exposed to a tribunal later for them to be criticised for having changed their mind, and produce a joint report before they each go into the detail of their own positions? A joint report that identifies that in relation to the questions asked, what do they agree upon and what do they disagree upon, leaving for their subsequent reports concentration on the areas of disagreement rather than a wholesale examination of every issue, which, where there is agreement, obviously needs no expansion. Now, all of these things demand, in my view, very early tribunal interaction with the parties and the experts to try and achieve these reasonably obvious and sensible outcomes. It is not, in my experience, achievable to maintain a process that is efficient and useful unless the tribunal gets in to deal with these issues right from the start of the arbitration. The concept of a hot tub was actually invented in domestic litigation in Australia. It's where the experts, when they come to give evidence at an evidentiary hearing, sit together physically and express views which can be tested together rather than treated in an adversarial way by being cross-examined separately without the tribunal having an opportunity to understand each of their views. Hot tubs are useful, but the value of a hot tub is greatly enhanced by having those areas I've identified above on this slide done well before the evidentiary hearing, by which time the horse is bolted, you might say, in terms of the value of a hot tub. And finally, I find, as a lawyer, not as skilled in mathematics as I would like to be, that it is of great assistance, particularly in quantum calculations, to have the experts help the tribunal get the figures right in their award. And I have found it exceptionally valuable for the parties to agree and the experts to also agree, which is often the case, that the tribunal can have access to the experts confidentially to just make sure they're getting their figures right for the tribunal in the outcome that the tribunal has reached, with the communications between the experts and the tribunal being available to the parties after the delivery of the award. So those are my comments on where we can do better, where there is, as identified in the ICC report, a range of options, but there is a lot of detail which needs to be filled in achieving the outcomes. And I hope that we will look at some of these issues when we come to the hot tub with the experts a little later. Thank you very much.
All right, we'll go ahead and pull up our second polling question. Again, you'll see that on the right side of your screen in a moment. What level of involvement should the tribunal have in guiding the use of expert evidence, in your opinion? Very hands-on, so for example, be involved in preliminary expert consultations. Moderate, say giving directions for joint expert reports and expert conferencing at the hearing. Or limited, really just limited to encouraging the parties' agreement on expert disciplines and then issues for the expert reports. All right, I'll close the poll now and hand things back over to Nick.
Thank you. Thank you, Doug, for highlighting the key recommendations of witness and expert evidence. You've drawn some very useful references to the existing practices of efficient arbitrators, some very recent innovations, the one you mentioned in the Commercial Court in London, and more general recommendations. And I'll return to some of those details when summing up the presentations later. May I have slide 16, please? At this point, I'm very pleased to now introduce my law partner, Frederick Gillion. He's joining you from Singapore to address all of us on Council's perspective on the production of witness and expert evidence in construction industry arbitrations in light of the revised report. Frederick is both a qualified French advocate and an English solicitor. He's based in our office in Singapore, and he specializes in construction dispute resolution, including construction arbitration. Over the last 20 years, Frederick has been advising companies in all aspects of construction projects, including as counsel in dispute board adjudications and arbitral proceedings. Now, over to you, Fred.
Thank you, Nick. And thank you, Doug, for this insightful presentation, which certainly resonates with me as counsel in arbitration proceedings. So now let's look precisely at the council's perspective and see whether there is in fact any consensus in terms of the management of techniques to streamline witness and expert evidence in construction arbitration. What I'm going to do is look first at some of the main features of witness and expert evidence in construction arbitration. Then I will examine some of the management techniques recommended by the ICC and others to streamline the process. Now, starting with fact witnesses, we first have to recognize that construction arbitrations are notoriously fact-intensive and technically complicated. This often leads to the production of rather lengthy and technical witness statements, which sometimes combine features of witness statements and expert report as recognized by the ICC Commission report. And this is particularly so when witnesses give an extensive account of the factual background to the disputes, with, for example, a detailed description of the delay or disruption events that have affected the works and also the effects of those disruption events on the works. And you could also have witnesses addressing issues to do with variations, and also describe the impact of those variations on the works, which usually involve technical issues. And for those of you who have been involved in the preparation of these witness statements, I mean, you will see that this is a significant task, which is highly time-consuming, both for the witness and also the counsel. And as a result, it is a costly exercise. And it's therefore not surprising that the ICC has sought to recommend some case management techniques to streamline the process in order to make it probably a less costly exercise, to define at the outset perhaps the role and content of the witness statements, and also to identify the facts which are not in dispute and which therefore should not require witness evidence. Now, looking at some of the typical issues which I've identified is the fact that in practice, first of all, we rarely see any attempt by tribunals to manage the contents of witness statements, even though depending on the legal background of the tribunal, they may consider, and maybe Doug, you may want to comment on that, but you may consider passages of witness statements which do not address disputed facts somehow a distraction more than anything else. And as we'll see in a moment, probably the reason why tribunals may be slightly reluctant to take a proactive role in on this front is probably because witness statements may serve other purposes beyond simply addressing disputed facts. And I should perhaps mention at this stage another report, a useful report produced by the ICC Commission on the accuracy of fact witness memory in international arbitration. It was published in 2020, and it looked at ways to enhance the probative value of fact witness evidence in international arbitration so that the effort and expense that go into the preparation of these witness statements are plainly justified. I don't have the time to go into the details of the finding of this report, but I definitely recommend you should read it. And I should just mention that the report highlights a different approach between generally counsel and arbitrators from a civil law background. Would be more inclined perhaps to consider that fact witness evidence would benefit from being limited to facts that are disputed and relevant to the outcome of the dispute, whilst counsel and arbitrators from a, let's say, a common law background could tend to accept a more, let's say, wider approach to fact witness evidence as being useful. Something maybe that you may want to discuss during the hot topic session and later in the webinar. Now, as with other areas of arbitral procedure, the international arbitration community has, sought to harmonize its approach to the presentation of witness evidence beyond the classic divide between civil law and common law, so as to provide some sort of a level playing field, and probably the IBA arbitration committee has played a particular significant role in this regard, most notably with the publication of the IBA rules on the taking of evidence. That said, the IBA rules, how useful it is, fall short of providing practical best practices to streamline the process of producing witness evidence. And Hazel has already touched upon some of the recommendations made by the ICC Commission report in order to reduce the cost of this exercise. I've again stated some of these and reproduced some of these on this slide. One is achieving some sort of consensus on the role and content of witness statements. Another one was to maintain only relevant witness statements. Then there's the use of video link and also using fact witnesses panels to streamline the process in complex cases where there tend to be many fact witnesses who have maybe complementary or supplementary information on the same subject. I suppose that the difficulty with these case management techniques recommended by the ICC report is that they do not necessarily consider the different reasons for producing witness statement. The ICC Commission report refers mostly to the first purpose, which is to prove disputed facts. But there may be other reasons to produce a witness statement. And to give you a commonly quoted example, witnesses can give general background information to set the scene in which the dispute has a reason. And when used in that way, it is quite possible that the evidence of a witness may not concern disputed facts at all, and of particular relevance to construction arbitration. You have obviously the typical story of the delays and disruption on the project, sometimes drafted in over many pages in a chronological way, or to describe the impact of those events on the contractor's progress, as I said before. And this may result in rather lengthy witness statements, and that's probably one of the main causes. But from my point of view, I think this is a very important part of the witness statement, which obviously, as long as the witness doesn't seek to advocate the party's case, is useful also for the the benefit of the tribunal to set the scene, to understand exactly all the story of the project and what has caused delays and disruption. So that's one element which may not be simply limited to disputed facts. Similarly, the meaning and significance of documentary evidence, for example, I don't know, a contract amendment granted an extension of time or additional cost in respect of variation may be also the subject of witness evidence, even though on its face, its interpretation could be simply the subject of legal submissions by the parties counsel. But I think, again, I find it quite useful for witnesses to explain the background behind this, the preparation of this contract amendment, for example, especially so in circumstances where the applicable law does allow the intention of the parties to be relevant when interpreting a contract. And this also, I suppose, particularly so when considering that the majority of the time taken at the hearing is consumed with witness evidence rather than legal submissions. Therefore, important to spend some time discussing possibly a key document, which is possibly, you know, settlement agreement or this contract amendment I've just mentioned. And finally, you do find in construction engineering disputes, you know, which are technical cases, witnesses giving evidence on really technical aspects of the disputes. And while this explanation may be left to expert witnesses, the parties' employees involved in such disputes may actually have a knowledge that equals the knowledge of experts, or actually be superior in case of highly specialized industry. And probably one of the questions here is actually, what do you do as a tribunal with this evidence? Does it stand as a simply witnesses of facts, or do we actually have some sort of other value by way of sort of expert evidence? But certainly I found that whatever you actually put in each category, it has a value, which is obviously to give a good explanation to the tribunal about the project in general, the functioning of a piece of machinery, for example, or even the root cause of a defect. And given all the various purposes of facts witness evidence, it seems to me rather difficult to seek to streamline the process of producing witness statements by simply limiting their contents to disputed facts, even though I can certainly understand that some tribunals, particularly from a civil law background, may be, let's say, frustrated with some witness statements which may be quite lengthy, which may not be on the point. And I suppose this is particularly so if some witness statements tend to advocate a case or make legal arguments or offer opinions on legal interpretation, which should not obviously be the place. But now, when looking at the ICC recommendations, so I mean, I've dealt with the recommendation to, if you want, limit witness statements to disputed facts, but there are obviously other recommendations made, which I think fit nicely in the attempt to streamline the process of and lengthy and probably costly exercise of producing witness statements. The first one is the use of this video link. I think this has been certainly the norm for the past 18 months or 2 years now. And we need to know now whether this is something that is to stay and will be actually kind of a norm for all witness statements to be turned into some virtual hearings, or whether in fact parties, counsels or arbitrators may regard the recourse to virtual questioning as being some sort of an exception to the rule, on the basis that somehow you get a better sense of the witnesses' reactions if they are present in the hearing room. And there may be also some concern that the witness credibility may be somehow impeded by video links. Finally, witness panels. This is the subject of the first question of our poll after Hazel's presentation. It's interesting because, I mean, in my experience, this is rarely used. I mean, I've never actually come across a proper panel of fact witnesses. This would be obviously commonly used in respect of expert evidence, but certainly not the norm. And certainly traditional ways of presenting witness testimony, in my view, will prevail. But I'll be again interested in the audience experience on this. Now, moving on to expert evidence. the fact that different legal cultures have taken different approaches to the presentation of evidence is, of course, also applicable in relation to expert evidence and should not be underestimated in the context of construction arbitration due to the critical role that experts played in construction cases. I've mentioned here some of the key challenges which I often face and which I will develop further in this presentation. The first one is, of course, the fine balance between supporting a party's case and being truly partisan, and that's something that no doubt will be mentioned during the hot top session. Second, the party's over-reliance on expert evidence. It is indeed not uncommon to see the other side essentially running its case through its experts. I mean, really relying on the opinion of its experts in respect of legal and also contractual issues. Hence my question here, should experts also opine on legal issues and issues of liability? Because this is something that you actually come across rather frequently. And this is particularly relevant in the context of delay expert reports, where experts may be tempted, I suppose, to go beyond a mere analysis of the cause of delays by allocating the risk of a delay event to one party or the other. Another key challenge is the tribunal's over-reliance on one party's expert evidence, and that's something that Doug mentioned earlier. And this is the direct result of the complexity of construction disputes and also the fact that tribunals are often provided with two fundamentally different expert reports, which may be using different data sets or different methodology. And without the assistance of a tribunal-appointed expert, the tribunal will therefore have no choice but solely to rely on one party's expert evidence and dismiss the other party's expert's evidence. The final challenge is the lack, in my experience, of a proactive role of the tribunal in managing expert evidence. For example, it's still rare for tribunals to direct the parties, delay experts to meet with a view to agreeing on the baseline or the critical path of a project or the methodology to analyze the delays. Or if we're looking at issues of quantum, to agree on a way, for example, to sample cost claimed by way of a joint audit, for example, or to produce a joint statement of points agreed or not agreed. And it's usually left to the parties to decide whether to hold these meetings. And when the procedural calendar does contemplate some meetings between experts, it's often after close of pleadings and only 2 or 3 months before the final hearing, which obviously it's actually quite late to agree on anything at that stage. Some consideration to prove the process. I mean, some of these have been actually mentioned by Doug, and we are clearly aligned here. Maybe assisting on common set of underlying facts and data at the outset would be beneficial. The timing of the experts' involvement is obviously important. Obviously, it should be before the hearing, and I'm a pro advocate to do it at a very early stage, during the hearing, of course, and also after the hearing. And that's something that we will consider a bit later on. And I think Doug mentioned the role that quantum expert can play after the hearing. And finally, question, should we reconsider using tribunal-appointed experts? It's certainly, as Doug again has said, something which is a distinctive feature of domestic litigation in most civil countries. And certainly in France, it's something that I'm used to, and I can tell you that actually the role of the expert then goes a long way in actually writing the decision for the judge. He doesn't stop simply at identifying, for example, the cause of delays or the defect. He will also critically allocate the responsibility for the delay to one party or the defects to another party. So that's something that we need to consider when we are contemplating the use of tribunal-appointed experts. Now, I'm conscious of time. I'm just going to go through a few considerations which I think are pretty key when we deal with actually some of the challenges. The first one is obviously selecting the right expert. It's probably on our agenda when we actually get the point is going to be our priority to get the right expert. And by right expert, I mean obviously not simply someone who has the proper qualification, the technical expertise, or the reputation in a particular field, but he has to be someone who is able to write expert reports and give evidence in proceedings. I'm obviously not solely in favor of having the professional expert. I need someone obviously who has experience of projects, but on the other hand, I've had experience of a non-professional expert, and this is a real challenge because you have someone who would be in a niche technical area, has never been actually, could be a professor, never actually testified before a court, and having the right format so that the information is intelligible to the tribunal is always an issue, and we can actually find that as well with sometimes law experts in some countries. Credibility is also key, and I suppose this is connected with the next point relating to the experts' independence and impartiality. To be credible, the expert will need to convey his or her expertise in an independent and impartial manner, but at the same time, his evidence should be useful to support the appointing party's case. Otherwise, it would be of limited benefit to produce expert evidence. So that's again this fine line which I've put here, the fine balance between supporting a party's case and being truly partisan. And that's something that the ICC has obviously recognized. And the ICC in particular refers to claims consultants, whom contractors frequently use to prepare their claims during the execution phase of the project or during dispute board proceedings. And the report of the ICC comments that it is not uncommon, it is now common for parties to use experts as consultants, and notes that the tribunal will need to differentiate the testimony from truly independent experts and that from such consultants. My view on this issue is probably more nuanced. I think we should move away from the common view that experts who may have been involved during the execution stage of a project are necessarily hired guns. I think the issue of independence and impartiality has more to do, in my view, with the expert's objectivity and his credibility. And of course, experts should avoid acting as advocates, and that's irrespective of whether they had some involvement prior to the arbitration, and they should be ready to concede points where it is appropriate to do so. And that goes a long way, in my view, in supporting that perception that an expert is truly objective. And similarly, experts should not stick rigidly to one fact scenario, and they should instead consider a range of possible outcomes depending on the tribunal's findings on disputed facts or disputed points of facts or law. And they should also consider the contrary views, the explanation provided by the opposing expert. And that makes actually the expert, probably the reply expert report, a lot more credible. And that's, I think, something that would be more useful for the tribunal, because it can then decide based on this different scenario the outcome based on both expert reports. Third consideration is bridging the gap between experts, because the potential of disagreement is obviously very, very common. So how do you bridge that gap? Well, the first thing would be to ensure that both experts have a common set of data. And as Doug has experienced, I think I can confirm that it's not always the case. And whether it's the native form of a program or access to the accounting information that underlies the cost of a project, you need to be able to scrutinize the data, and having the common set of data is important. And I think it's probably part of the tribunal's role as well to, at the outset, to recognize that this common data is essential for the parties to talk the same language. The report of the ICC also recommends that tribunals and parties should seek to limit the potential for disagreement between experts by requiring, and I quote, the experts should discuss their views with each other either ideally before or otherwise after preparing their experts' reports, as most independent experts eventually see eye to eye on many things. I can confirm this is certainly the case. And as I said, I'm a fair believer in the benefits of meetings between experts, but I have to say that it's rare in practice that tribunals would prescribe meetings between experts. More often than not, this is left as an option in procedural orders when there's a clear provision for experts meetings. As I said before, it would be actually right at the end, after close of pleadings. At that point in time, 2 months or 3 months before the final hearing, there's absolutely no benefit, and actually absolutely no benefit in having experts meetings, because both parties, expert will be entrenched in what they've said in their reports, probably in their second reply reports. So limited benefit then. On the other hand, what I've seen actually recently is using midstream CMC, which you see actually a lot more in arbitration, as a trigger for meetings between experts. It would be a good opportunity at that stage, which would be halfway, or would be simply after the statement of defense is filed, for the tribunal to reflect on the issues, having read the statement of claim and statement of defense, and actually identify the issues on which truly there may be benefit from expert evidence, and invite the parties, experts then to meet, and over a period of a few months, try to actually produce their joint reports. That would be, in my view, of great benefit for the tribunal. I've mentioned here experts, witnesses, conferencing. That's something that is obviously commonly used nowadays. I should probably just mention just a red flag. Sometimes I've seen it being used when the tribunal is not fully informed or fully prepared, because obviously the idea is actually to leave it to the tribunal to ensure that it is conducting a little bit the cross-examination himself, and that could be done only if the tribunal is obviously fully prepared to do so. And finally, post-hearing involvement, that's key thing, I think, which may not be simply limited to the calculation of financing charges, which is done commonly, because I think arbitrators, like lawyers, counsel, are not very well equipped in calculating interest. But I think it can go beyond that, and it's just, you know, looking at prolongation cost, depending on the outcome of the tribunal's findings, having the expert to determine the amount of prolongation cost based on number of days of delays. It's something that could be done with the help of an expert after the hearing has taken place. That's something that actually I do not see very often, but would be actually a very beneficial actually for the tribunal, but also for the parties to have a bit more certainty in the outcome, because then the tribunal will not be left in simply choosing one party's expert's evidence. Finally, tribunal appointed experts, an effective tool. Well, maybe. I'm not convinced that because it's not being used commonly in international arbitration that we shouldn't consider tribunal appointed experts. I think it has a cost for sure, but certainly reduce experts partisanship, and it may actually avoid this, what I've mentioned, the over reliance of the tribunal on one expert's conclusion, since he would have now a third-party expert to assist. But obviously, the risk obviously is the fact that there may be this over reliance on that tribunal appointed expert, who would be then some sort of a pseudo arbitrator who would write you know, on some key issues part of the award, which obviously is a risk, but that could be, in my view, managed properly by the tribunal. Now, as a conclusion, just a word by saying that I think there's a general consensus that you know, witness expert evidence is obviously an expensive part of the arbitration cost, and should be streamlined by way of more proactive engagement of the tribunal, and this throughout the process. One thing that I've noticed in the ICC Commission report, there's no mention really of this key distinction between what I say English style memorials, you understand, the sequential style of pleadings, which will be then followed by witness statements and expert reports, and memorial style pleadings, which will have in one place, memorials, both the actual evidence, documentary evidence, witness evidence, and expert evidence at the outset. I think memorial style pleadings, despite the fact that it is being commonly used, may be an obstacle to the proper management of expert evidence in construction arbitration, because you are forced in a way to have at the very early stage all your evidence in one place, and it's very difficult then to narrow down the issues and for the tribunal to manage the process. So maybe as a suggestion, and I'm not sure if it's been ever used, but it would be some sort of hybrid, is having maybe memorials with fact witnesses, and then after close of a pleadings, having rounds of expert evidence. That way the expert can concentrate on the issues that come out of the pleadings, and that way the tribunal will be probably better placed to manage the process. Thank you.
We're going to go ahead and ask our final polling question now. Would you submit a hybrid statement from a witness who combines the features of both a factual witness and an expert witness? So this contemplates a hybrid situation where you might have a fact witness who can also give an expert opinion on the subject. Maybe that's a welding engineer on one of the projects. And I'll ask you to keep in mind that this hybrid approach could affect how much weight the tribunal ends up giving to that statement ultimately. All right, let's go ahead and close the poll and stay tuned for some of the more interesting results that we'll cover later on. Nick, I'll hand back over to you.
Thanks, Andrea, and thank you, Frederick. As I had expected you would, you've shared some very practical and heavily experience-based observations on the reality of how disparity in practice between best practice as illustrated in the revised report and current practice and the ranges of practice and some of the challenges and areas for possible reform. And I'll touch upon more particularly some of the points you've made when I'm seeking to sum up the presentations. May I have slide 29, please? Ladies and gentlemen, in somewhat of a departure from the traditions of this seminar series, this now brings us to the hot tub. I'm going to then pass the baton over to Doug.
Have the next slide, please. Well, we have an exceptionally experienced panel of expert witnesses. And this panel is intended to let them have their say about what they think they can do to more effectively contribute to the outcome of construction disputes. They're knocked around by counsel in cross-examination, they're knocked around by their own counsel, and they're knocked around by tribunals. This is their chance to actually say what they think, and I think it will be a very important perspective. We've got very limited time, 40 minutes only, and we've devised a series of questions that I will mention in a moment, that a couple of them each will contribute to each question. It would be wonderful to have them all contributing to all the questions, but time does not allow. Let me briefly introduce them. Jerry Brannigan is a partner of HKA and head of the Global Forensic Technical Services Group. He's a chartered building services engineer with over 20 years experience, and he's been appointed as a technical expert on more than 50 occasions, acting in jurisdictions around the world. He's got a design background in engineering and project management, and obviously has a key input in relation to building services in particular. Don Harvey is the founder and managing director of Secretariat. He has over 25 years experience in the construction industry and specializes in delay and disruption analyses. He's given evidence as an expert witness in many jurisdictions and arbitrations seated around the world. Joanne Pryor is a managing director of Kroll and a chartered quantity surveyor with over 30 years experience in the construction industry. She's appointed as a quantum expert and has considerable testifying experience. She's experienced working on large complex construction projects, the UK, Europe, Africa, Australia, the Far East and the Middle East. She has an honours degree in quantity surveying, a master's in business administration and a postgraduate diploma in law and arbitration. She's a fellow of the Chartered Institute and sits as an RICS assessment person in relation to professional competence assessment. Michael Stokes is a senior managing director and practice lead for Ancura's construction disputes and advisory practice outside of the Americas. With a background in both contracting and consulting, he's got over 30 years experience in the industry. In recent years, he has specialized in expert work, having been appointed in international arbitration as an independent expert specializing in quantum and disruption on more than 50 occasions. James Taylor is a senior managing director and leader of the Singapore Construction Solutions team for FTI Consulting. He's also a chartered quantity surveyor with over 30 years' experience. He's been appointed a quantum expert on numerous projects with testifying experience in international and domestic arbitration and in the Singapore High Court. James has experience in a wide range of large and complex projects covering Europe, Africa, Asia, Middle East, Americas, and Australia. He's a chartered quantity surveyor and a practicing member of the Academy of Experts and a fellow of the Chartered Institute of Arbitrators. In our fascinating discussion preparing for this session, we decided that we would try to address 4 issues, there being many others that were of interest. The first is the value of joint reports. The second is data and disclosure. The third is the role of the tribunal. And the fourth is the independence of the expert, particularly where they have had a role in the preparation of claims and the like. May I have the next slide, please? The first question is, what are the benefits of and issues with different approaches to producing reports? When is it most effective to produce a joint report? How might views on joint reports vary between quantum, delay, and disruption experts? Joanne and James will head off the discussion on this. First, Joanne.
Thanks very much, Doug. Well, as a general principle, I think joint expert reports are extremely useful. They get the experts talking, and if you strike up a conversation where you can understand each other's positions, you can quite often come to areas of agreement, which will save a lot of time and effort in the long term. The thing I would say about joint expert reports is that the timing is key. In order to understand the agreement you're making and the impact of the agreement you're making, I think you have to have a good understanding of the facts of the case and the detail and the evidence that's going to be available to you. So therefore, if you're making decisions very early in the case where you don't have a good understanding of the facts, it can lead to issues later on. So for me, the timing of it is important. I think it's, in my experience, it's been good to have done your expert report first so that you get to see the other party's position in writing and understand your case and understand the information that's available. I think one of the things that has been useful in the past is not necessarily to do an expert report first, but to maybe, as been suggested, do a without prejudice report. So you're exchanging your views in writing beforehand and then speak to your opposite party. I think what might be helpful, or what tribunals might want to consider doing, is getting the experts to speak early. I quite often do that with people I know, and I find that very helpful, and it can really reduce time and effort for both the experts and the parties in the long run. So I think really good to do, but timing is important.
Now that's a perspective from the quantum side of life. Perhaps we could ask for a delay and disruption perspective from Don.
Thanks, Doug. I agree with what Joanne said. I think understanding the detail, of the project, what happened, is very important before you produce a joint report. But in my experience, from a delay and disruption perspective, having multiple joint expert reports is helpful. I think one of the issues that occurs with delay and disruption is you have disputes about baseline schedules, methodologies, data sets. And I think early on in the process, sitting down with your counterpart and trying to agree, what is an appropriate baseline schedule, what is an appropriate methodology, and what data that you're going to use will help, maximize the agreements and minimize the disagreements going forward, which I think is ultimately the goal for delay and disruption experts in order to be effective to the tribunal. So I think having, almost a preliminary joint statement where that stuff is set out and agreed to the extent possible, and then a joint statement later on to address the disagreements has been effective.
So that's quantum and delay and disruption. Jerry, of course, brings a much more technical approach to the evidence he's giving in terms of MEP and the like. Jerry, what's your view about this issue?
Yeah, I think it's very important, and I completely agree with Joanne and Don that getting that information clear at the beginning in terms of what the basis of the analysis is going to be means that the reports are going to be moved ahead in a similar way by both experts. So understanding what position the basis of analysis is going to be, especially in technical, where quite often is in respect to a legal position on, for example, the allocation of design responsibility, which may actually be a legal argument in the dispute. So therefore you could result, without any clarification of that at the beginning, you may result in a report which is been provided by each expert from a completely polar opposite point of view. Having that discussion and agreement at the beginning about what that basis of analysis actually is will allow us to understand that at the earlier stage as possible, there may be two legal positions that the expert may have to provide alternative opinions on. And that will allow effectively the tribunal to see where the experts agree on a particular technical opinion from a particular legal factual point of view, but that both experts are providing both opinions on those 2 points of view. So the matters of fact, law and interpretation can be dealt with by the tribunal at a later stage, knowing what the technical opinion is on the basis of those, on that basis of analysis.
Thank you. We might move now, in the interest of time, to our second topic. May I have the next slide, please? Data and disclosure, which we have there. What value do common data sets have for experts on both sides? What input should experts have into document production requests? And do experts feel empowered to get the documents they feel they really need? James, would you like to kick off on that?
Sure, thanks, Doug. Taking the first point, the common data set, I mean, it's just incredibly important that we are, as experts, working from the same data set. I think, as Jerry mentioned, you can end up with two completely separate reports coming in if you're working on different data sets. And I think that does kind of cross in with the first point about when to get the experts involved and when to have a joint statement. Because if you do get the experts involved early with an early joint statement, it becomes a lot more likely that you're going to have the same data set. I mean, I've personally had a number of issues where you have the standard approach of doing an expert report, then a reply, and then a joint statement. And so much new data comes in appended to the other expert's first report. And you've not had a chance to look at that for your first report. So you only get one chance to reply to it. And basically your first reports effectively become useless at that point because so much new data becomes available to both parties. So I think it's really, really important to get that common data set right at the beginning. In terms of document production, I've found that the lawyers have always approached us to ask us about data requests. The one thing I would then go on to say is they won't always ask for the data that we say we want because of tactical reasons for themselves in terms of, well, if we ask for that data, the other side are going to ask for something else, and we don't want to, or we're objecting to the other side's request for something, therefore we don't want to ask for it ourselves. So yes, we have an input into that request, but whether we actually get our way with the request is another issue, I think.
Do you get access to the tribunal at all?
No.
I don't think I've ever had access to the tribunal to actually ask for data. And I think that brings up a couple of issues in itself. The lawyers are not necessarily going to be happy if you do get that direct approach, that direct ability to approach the tribunal, because they will have particular reasons why they don't want to ask for data. But one thing I think, I mean, just from personal experience, I did have one time where we actually had a meeting with the tribunal, the two experts before the hearing, and I'd had a bit of problem with the other expert about agreeing how to present some stuff, and he was he wouldn't move on it at all. And actually, when we discussed it with the tribunal said, no, that's how we want it. So just go ahead and get it done. And I think the tribunal can be, that can be a very effective means to get the experts to come from quite opposed positions to actually having to agree early to present information in a way that is more beneficial to the tribunal.
Don, any views on this?
Absolutely. I think on the first point, I think it's an absolute necessity that both experts are working from a common set of data. And I think even more importantly, to the extent you can get agreement on which data you're going to use. So take, for example, as-built data, as most people probably on the participating know, on construction projects, you have thousands and thousands of bits of, reports and dates. And, on just about any date used in an as-built schedule, you can always find conflicting, other data sets that will have conflicting dates. And, from my perspective, to try to minimize the disagreements and maximize the agreements, if you can work from the same set of data and agree that data set, I think that's very, very helpful. In relation to having input on production requests, obviously I've been involved with many red fern requests, and there's obviously pros and cons with that whole process, and I won't get into that. But one of the points you asked, Doug, was have you ever been in front of a tribunal in relation to document requests? And I have been on one instance, and you were the chairman of that tribunal. It was a case in Dubai where you called the experts. It was a disruption analysis, and you called us up in front of the room and said, okay, how are you going to analyze disruption and what do you need? And to me, I thought it was, it was incredibly, obviously, and this was probably 10 years ago. Very pioneering approach, but very effective and very efficient. And, so from my perspective, it cut right to the point, and it cut out the tactical maneuvers that the firms of solicitors typically use to delay and hinder the process. So and I think that hits the last point on the slide as well. I certainly felt empowered when I sat in front of the tribunal and explained how I was going to do something and what I needed to do it.
Brings us neatly, I think, to our third topic, which is the role of the tribunal. We haven't agreed to discuss the role of counsel because that's a bit close to the bone for the experts who are engaged by counsel on a regular basis. But now's the chance to weigh in on what you think the tribunals can do better to make your work more valuable for parties and the tribunal. And sharing some experiences of what's good and what's bad would be really helpful. Jerry, would you like to kick off on that?
Yes, of course. I have found that probably the most useful tribunal is the one that requests the experts to be part of some of the CMCs leading up to the hearing. I've on a hearing again in front of yourself, Professor Jones, the ability for the tribunal to direct the experts in front of all of the counsel and solicitors, instructing solicitors, to direct us on where you needed us to get to by the time we sat in the hearing was really, really useful, because it gave us clear direction, and take out all of the tactical issues that potentially were being utilised that we as experts didn't really know about, shouldn't have known about. And it allowed us to get closer together on some of those factual, some of those opinion issues, and direct us, and especially where there is points of legal dispute, directing us where you needed the opinions to be considered in terms of how we were basing our opinion. And it effectively allowed far clearer technical opinion to be given forward, where there was very little actually in dispute other than what was related to the legal arguments. And I found that intervention by the tribunal on that occasion very useful. In terms of other tribunals, which the first time you speak to anybody in relation to the tribunal is when you're sitting being cross-examined. Very, very, you've not got any input and you've not had any direction. You don't know what direction the tribunal are trying to get you to go towards, because it's quite clear that the whole process of arbitration is a process. It's got different parts to it, but sometimes you only get that very end part to it, and I think that is not as good, because as in terms of the last point, there is no there's no way to prevent the over influence by the lawyers, and that's the only people you get to talk to.
James?
Yeah, I mean, I agree with Jerry. I think the just like an overarching point is that if you've got a very hands-on, proactive tribunal, you're going to get a much better product out of the experts at the end. Making the experts stick to the questions. I just had a recent arbitration where the lawyers couldn't agree on the list of questions. So we ended up with a list of questions from each lawyer, which is particularly unhelpful. You know, if the tribunal had actually got involved and I think told them to go away and actually agree the questions, that would have been a much better approach. And also, I think, you know, an early or a continuing interaction with the tribunal. Also, I mean, in the same arbitration, the other expert basically didn't give any. He took his own client's point of view and gave his opinion on that, but didn't give a real decent opinion on assuming that the facts of the other side were correct, what his opinion would have been. And you know, when it comes down to it, when through cross-examination, he basically agreed that the assessment that we had done was correct if you took our assessment. Now, we could have shortcutted the whole thing had he actually dealt with that early on and had the tribunal been more hands-on with the way that it had been approached. So I certainly think that a hands-on tribunal can reduce the costs involved. I mean, there were a lot of costs involved in writing reports that effectively eventually became agreed issues, but only under cross-examination because he was forced to deal with them. So, you know, I think those are two key issues there.
Michael, have you got any views on this tribunal role? Because I think there's a value in hearing from you experts, which is a message to all of the participants, to the clients on this webinar and to counsel on this webinar, as to what your level of comfort as experts is in relation to tribunal involvement.
Sorry, who was that to? Was that to me?
Michael?
Yes, Doug, thank you. Well, my view is, generally speaking, whenever the tribunal are involved and actively engaged in managing the expert process, it does become a more efficient and controlled process. So from that experience point of view, I'd be, you know, I am always very, very supportive of it. You know, my own experience is, I think many of the panelists have already said it. What it does is it tends to take away the ability of some of the tactical manoeuvring, perhaps, which understandably council will adopt at times given their role. But the tribunal searching really for the most accurate and useful questions to be answered, you know, that involvement is usually a force for good.
So, Michael, just moving on from that comment, perhaps to our final point, which is independence. It's very well established, and all of you would recognise that there is now established as a principle accepted by everyone, by the parties, by council, by the tribunal, that party-appointed experts are meant to be independent expert assistants to the tribunal. Now, there is obviously a huge tension in that process where you're being paid by the party who's appointed you. You are looking for further work from that law firm or that party for the future, yet you're accepting a principle that you will be an independent assistant as an expert to the tribunal. Now, one of the things that interests me, two things in this area. The first is that question which is raised by the ICC Commission report of, can you fulfill that independent role when you have been part of a team developing a case theory for a particular client, where you've been preparing the claim and you've been in the case for a long time? Is there a capacity for independence in that context? And the second thing is, how do you as an expert insulate yourself from the pressures, the commercial pressures which obviously are there, that I've mentioned? Who pays you, who's going to give you further work, in order to perform that independent role that everyone accepts you have to perform?
You've asked some great questions there, Doug, and you got right to the heart of the matter. I mean, the importance of independence for experts, you know, simply can't be understated. Along with the expert having true subject matter expertise, his or her independence is of vital importance, and that's reflected in the ICC Commission's report, you know, where they suggest or recommend that in the first procedural order, the tribunal require that all experts put a declaration of independence within their reports, which is absolutely standard procedure and understandable. So turning to the question, and interestingly, without any preparation of this, I completely agree with some of the comments that Frederick made earlier, and the phrase he used was nuanced. But the question is very, very nuanced. But fundamentally, at the heart of it, where I sit on this, is that it's not so much what you're asking the expert to do that can create a position of bias, if you like, but really the conduct and attitude and professionalism of the expert. So put that another way, an expert appointed at any stage can choose to be either biased or unbiased in the way that they carry out their work. So it's a very nuanced question. The ICC Commission report talks about experts that are unconnected with the parties and distinguishing those from experts that have a close proximity to the parties. And it seems to me that whilst we can all understand the dynamics that are being described there, that's incredibly difficult to police or to review and understand through the process. So I think ultimately this nuanced question comes down to the judgment, unfortunately for you, I guess, Professor Jones, in your role, to the judgment of the tribunal as to the independence of the expert evidence that's being heard. And you know, if I just give you a couple of personal examples to show the difficulties, it's very common in very, very complex sort of delay and particularly disruption analyses But even where the parties have spent a considerable amount of time and money producing a claim, that an independent expert would look at that claim and determine, with a different set of records and a different methodology, that there is a much more accurate and reasonable analysis that should be put before the tribunal, because that's your honest opinion as to what will give the most accurate result. And clearly the tribunal would want to see that evidence. And if you think about that as a matter of principle, preparing that after a claim has been prepared, because you're effectively preparing it from scratch, is really no different to appointing an expert at a very early stage. So ultimately, my view of the question is it's for the expert to conduct himself in an independent way. All the risks of close proximity need to be weighed up all the way through, and if at any point you feel that you have crossed the line, that you can no longer be independent, then that is a position you have to face, with your lawyers as you're being instructed. Just very briefly to your final point, I mean, how do you resist the pressures? And absolutely those pressures are there. There's a lot of money at stake in these cases, and a lot of pressure through all of the team. I think really it comes down to experience, and experience when you've been through many arbitrations through to the substantive hearing, and you understand how the evidence will, how the process will run all the way through. So for me, the key is understanding the claims deeply very early on. And if you have a very, if you have a very different opinion of the claims to those pleaded, the sooner that that opinion can start to be expressed clearly and with sort of fully supported, the better. But you have to be ready that at any stage, if you need to change your opinion based on new information or whatever, as an independent expert, that's really what you need to do.
Thank you, Michael. Joanne, on the quantum side, a lot of the work that you would do is verification of expenditures, agreement on figures as figures, and the like. So the opportunity for your deployment of independence is perhaps more likely to be objectively available than in some other areas of potential expert evidence, such as delay views, where different theories can produce different outcomes. And I'm reminded, as I ask you to contribute to this topic, of an experience I had in a Singapore arbitration where two quantum experts had done an excellent job of agreeing on what could be established from the accounts of the claimant were justifiable. And the expert for the claimant had disowned, if you will, some aspects of amounts claimed, saying there was no justification for them. And at the commencement of the second last day of the hearing, the client unexpectedly leapt up at the commencement of the hearing and said, "I wish to disown this expert. I do not agree with the outcome that my expert has reached. I am continuing to claim these amounts of money." After counsel for that party had got up from under the table, the counsel said, I thought quite bravely, "We do not resile from the expert's opinion." Now, that was an extreme example of the sort of issue that faces quantum experts, and I am interested in your views about this issue.
I can imagine that was, we're amused by it now, but I can imagine that was quite dramatic at the time. I think it's a tricky issue, and there's a balance to be struck, really. I think if you're involved with the pleadings and being involved in what's being drafted at that stage, effectively you've got your fingerprints all over the pleadings, and then when you go to look at it independently, there's an argument that says you're marking your own homework. So there's that dynamic going on, as well as on the other side of that. If you get your experts involved at an early stage, they would be able to give you some advice after the claim's been prepared, or there's a fair bit of work being done, as to what they would expect to see. And I think you can do that very independently by saying, I'd expect to see these documents to support this. This is how you would normally carry out this type of analysis. You know, we can verify this and sample that, and help the parties. And I think that can be very useful to both the parties, the experts, and also the tribunal, because if you say at an early stage, look, that's just not going to fly, or you know, there's no information around that as it stands, we wouldn't really be able to verify or support that case, then the parties know where their strengths and weaknesses are early on, and they can choose then to focus on their strengths, which is quite often a good tactic for them, and they might well consider where you've said something is particularly weak, whether they want to go ahead with that, rather than and what I've seen happen is that they either don't understand that the particular claim isn't very strong, or they have an expert that goes along with things, and invariably it comes out in the wash in front of the tribunal, that the information doesn't exist, that the claim isn't right, and actually it's wasted not only their effort on their claim, but it's also wasted a lot of time and energy. So I think getting involved early and giving an independent opinion can be really helpful. I just don't think you should have your fingerprints all over the pleadings and mark your own homework.
Thank you, Joanne, and thank all of you. We could go on and on this topic, and I would love to hear from all of you a lot more contributions than time allows. But I must say, I'm very grateful for the contributions you've made within this relatively short period of time, because they're the views of a very important group of professionals in the construction industry arbitration space that are not necessarily listened to by the whole cohort of those of us involved. So thank you very much indeed for your contributions, limited though they might be by the time that we have available. Thank you.
Thank you very much, Doug, and thank you, panelists of the hot tub. At this point in the seminar, conscious of the limited remaining time, whilst I've been taking copious notes of the presentations in readiness to summarize them in the course of 5 minutes, I think it might be a better use of the limited time to open the floor to questions, because we have had a number of questions posted throughout the course of the seminar. So I'm going to, with your indulgence, mention firstly that this entire seminar is being recorded. And if anyone wishes, I can follow up with a written synopsis. But with that said, I'd like to pass us, please, directly to the question and answer session. So may I please call up slide 36 and invite the virtual panel comprising Hazeltine, Doug, and Frederick to come together to assist with the questions. It's only going to last for about 5 minutes before we have to close. There is a question and answer box that should be appearing on the right side of your screen. So if you wish to raise any last minute questions, then please do use that box. That said, as I said, there have been questions raised, and one of them I would like to please raise. It's been posted by a person who I know is an international commercial arbitrator attending. I don't believe I have license to identify the person. The question is this: one issue is resistance by lawyers to experts meeting alone. The argument that lawyers make is that there could be an overlap between the expert issues and legal issues. How best can a tribunal handle that concern raised by parties' representative? Doug, if you wouldn't mind, if I could ask you, please, in the first instance, to consider how a tribunal might approach that sort of concern.
Well, if the question relates to tribunals meeting without counsel, with the experts, my own view is that that is counterproductive, because the nervousness of counsel, of having experts behave completely independently, is naturally huge. And they need to feel that they have an involvement in the process in order for the process to work. Arbitration is in many ways a mediated process. That is a process which everyone is comfortable with. I have never personally excluded counsel from any discussions that the tribunal has had with experts. I have not found that limits the value of the direct engagement between the tribunal and the experts. And I'm talking about case management conferences here rather than the evidentiary hearing. Counsel contribute positively because they see that there is real value in guiding the process so far as there are legal issues in that discussion. And that's just been my experience. I know there are some arbitrators who believe that you should keep counsel out of meetings between the tribunal and the experts, but I've never done that, and I've never seen a need to do it.
Thank you very much. Frederick, Hazel, do you have anything to add in relation to that question before we move to the next?
Perhaps quickly, I'll just add a point. If this question is in relation to the experts meeting, which is between the experts alone, because it's not clear whether that's a reference, then in that case, there has been some resistance from counsel for the experts to meet alone. What may help is the fact that both counsels would not be present during the experts meeting. In that case, it's in a way neutralized because neither expert has a lawyer by their side. Another way to prevent any such prejudice could be to agree beforehand on the issues or the agenda to be discussed during the experts meeting, and to ensure that it doesn't include any legal admission or liability issues. Thank you.
Thank you, Hazel.
Yes, no, I certainly agree with Hazel. I mean, the issue I've experienced as well is to make sure that the issues are really set out ahead of the experts meetings, and that's where you do address potential overlap with legal issues, which should be avoided. The reality is when you have experts meetings, there will be a lot of prep ahead of these expert meetings with parties counsel, and the experts will be briefed properly on what they should be saying or not saying. But then the reality is the benefit of this expert meeting is obviously they should actually try to be open about the technical issues and all the other issues that is underlying this experts meeting. So I don't think this should be an issue of resistance, and if there is, it's probably a misunderstanding by the other side's lawyers as to what the process entails.
Thank you, Fred. Moving right along to a next question that seems to be rather popular. The question is double-barreled. Firstly, what can be done to encourage tribunals to share their preliminary views with the parties at an early stage of the arbitration as to what facts and opinions are relevant and material? And the second element is such encouragement by of a tribunal to share its views appropriate? I'd ask you, Fred, I think from your perspective, the second aspect of that is perhaps most material to your role.
It's amusing because I've been involved in expertise proceedings, ICC expertise proceedings, both as expert and as counsel, and it would be very open, a very open way to communicate as an expert your preliminary views on the party's case, and that would actually probably help both parties to present differently their arguments. But that would be part of a number of experts meetings that you would actually organize. So certainly I can see benefits in that. I think it's maybe different in terms of arbitration proceedings. I can see certainly some arbitrators being quite reluctant to actually make any sort of findings at an early stage. That said, I keep talking about the midstream CMC, but the midstream CMC is really useful because without actually having drawn any conclusions on particular issues, it does help the tribunal to actually express some ideas and concerns, and there's not going to be findings on the merits of the dispute, but at least it would actually help expressing how the dispute can be managed properly. So I think that would be the right forum.
Thank you very much. Professor Hazel, any
I
insight?
can perhaps just quickly add what we've seen in some arbitrations, rather than express a view on the parties' positions in case. What we have seen is in some of the midstream CMCs that Frederick spoke of, tribunal members have been quite open to circulate a list of issues that he wants parties to address him on. And those could be factual, it could be technical, and such lists of issues would usually help parties decide whether they need expert evidence or factual evidence in those areas. So the sooner that can be circulated, I think that would be better for parties.
Yes, so perhaps not so mid as early for that CMC. Professor, do you have anything to add?
I have a process that I found to be very valuable after the first round of exchanges of case. I try to organise midstream CMC. I call it an issue CMC, at which the tribunal from the two parties' cases produces a summary of what it thinks each party's case is about, and invites the parties in discussion to comment on what they think the tribunal summary is worth, and have the experts at that meeting. The purpose of the meeting is firstly to hone the expert evidence, secondly to ensure the tribunal understands the real issues and gets the parties' input on that, and thirdly to make suggestions to the parties about what critically relevant material, expert or factual, needs to be done for the purpose of the reply process, so as to avoid every tree in the forest being cut down during the reply process at least, and have the parties focus on what's really critical. I've never done the Swiss process of actually expressing a view on the outcome. And as many of you would know, that's a well-developed Swiss practice by Swiss arbitrators who, with the consent of the parties, will express a preliminary view. Now, I haven't done that. There's been no real opportunity to do it. I'm interested in it, of course, because it sounds fascinating. I don't know what the statistics are of settlement thereafter, which would be, I think, a relevant thing to know.
Yes, indeed. Thank you very much indeed. Folks, I think we've probably run out of time, and I'm going to need to close the question and answer panel and indeed the seminar itself. With that, I will thank you all once again for attending today's seminar. To those of you who have been following the seminar series from the beginning, in November 2019, we'd like to thank you for your attention throughout, and we hope you found this series interesting and useful. If today was your first attendance, then equally, we hope you found it interesting and useful. If you wish to view any of the past seminars, then do get in touch with us. We can arrange that for you. Indeed, there's access directly to the recordings on the Pinsent Masons website in the seminar section. For all, we do hope that you'll join us again at the Part 6 seminar in the series. That will be the final part of the series, and it will focus attention on the very important subject of party settlement in construction industry arbitrations. The date is yet to be advised, although it will occur within some months from today, and you'll all again be duly invited. So with that, thanks once again, ladies and gentlemen. Thank you, fellow panelists and presenters. Here's wishing you all a safe and successful day. Take care. Bye-bye.
This concludes our session for today. Speakers, please stand by.